which has seen Kenyans lose a lot.
Yes.
Taxpayers' money.
Yes.
And I am seated here wondering what you have in mind in regards to that, to ensure that at least there is better way of doing this.
Yeah. The Office of the Attorney General is supposed to be the principal legal advisor to the government.
Yes.
You know who the government is, isn't it?
Yes.
The 3 arms of government. Now, we are hoping that we will be involved in most of these matters from the beginning, so that we don't do postmortem. Postmortem meaning after the fact. Because the Attorney General is always brought in after the fact. There's very little you can do.
Yes.
So if it was a bad case, if the provisions of a contract were not good, there's no way you can deal with it. So we don't want to come after the fact. We want to work with the government ministries from the beginning so that we inform them or we advise them on how we can cushion the government. But should it be that this matter must go to court, we will put our best foot forward. And that is why I talked about a strategic litigation department that will be able to respond to cases which are of serious nature, which touch on national security, economic development, our stability as a country. And this will be a team that will be supported by experts, because you find that the Office of the Attorney General, most of them are legal. You might need a financial expert, a tax expert, a procurement expert. So it will be a multidisciplinary team that is able to defend the government. Secondly, there are cases where you don't have to go to court if you have a bad case. For example, somebody has already finalized a contract and they want to be paid, but because of exchequer issues, we don't pay them. Then they end up going to court. So we have to embrace ADR, alternative dispute resolution mechanisms, mediation. And also, as we do that, we do a risk assessment. What will it cost the government if we have to defend the government to the end? So after doing the risk assessment, we will do what is in the public interest.
You said that sometimes the Office of Attorney General, there is nothing much you can do. And I am seated here also wondering, is it time also we expand the mandate of
Not that
this
there's
great
nothing.
office?
I was talking with regard to sometimes cases that come to us. For example, let's say malicious prosecution. Somebody has already gone to court. They already have an award from court. Now, the Office of the Attorney General is supposed to enforce the award. Now, you realize you were not there from the beginning.
True.
These matters are being brought to us at the tail end, where now people want to enforce their judgments. If we talk about contracts, everything has been done to the end. We were not there before. For example, we'll be able to tell you, if you put this clause here, if you don't put a clause on mediation, arbitration, then the only alternative is going to court. So if you were not there to advise you to cushion the government when you're doing the contract, it will be very difficult for us to now advise you after the fact.
Yes.
That's why I was talking about after the fact.